So it's my great pleasure to present this CPD. The speaker is a man very dear to my heart, and it just so happens to be an auspicious occasion. 50 years ago, last month, on the 1st of April of 1969, Richard Kenzie was admitted to legal practice.
First of April.
He doesn't. First of April. I know.
Is it a real charge?
The whole thing's a joke. He didn't actually get a degree at all. And we are very fortunate, of course, because those of you that know Richard, he's one of the very few people at the bar that can say he's had a high court practice. And as part of that high court practice, he was involved in a particular area of constitutional law, which, if you've had a look at the paper, we've called the Doctrine of Implied Intergovernmental Immunities. And that is, of course, the subject matter of today's CPD. Now, Richard's going to concentrate particularly on the cases that he's been involved in. I'm just going to give a brief few-minute introduction, if I could, to the topic, because it's a very interesting topic. It's the story of federalism. Of course, we live in a federal polity, but federalism was born, as far as the Australian experience goes, in the USA in about 1787, 1788. That was 10 years after the US was at war with the British. And in 1777, just 1 year after the Declaration of Independence, the British had taken Philadelphia, and it was General Washington's great task to win back Philadelphia. And he had a motley crew of soldiers. He had about 15,000, but winter had set in. So they went into winter camp about 20 miles out of Philadelphia while the British were in Philadelphia with a far superior force. Out of about 12,000, 15,000 soldiers, 10% of them died in the ensuing months from starvation and cold. Now, this is important to the story of federalism because in amongst the common soldiers was a young lieutenant who was only about 20 years old. His name was John Marshall. John Marshall is the Owen Dixon of American jurisprudence. He was their greatest chief judge. And what had happened in Valley Forge was that, this is an extract from his book, there were starving men. They were roasting their leather shoes to provide one more meal. That's what it had come to. And the reason why it come to that is because at that stage there was a confederation of states trying to fend off the British. There was no national government. There was no executive. There was only legislative power within the states, and there was no ability, therefore, for them to reach a common agreement as to how to even fund the army. And so the army was stuck there, starving to death. And of course, years later, when John Marshall finally rose to or was elevated to the position of Chief Justice, that experience informed what he did next, and he decided a case which became seminal, certainly in Australian jurisprudence. If you've had a chance to skim over the paper, you'll see that McCulloch in Maryland features prominently in the early decisions of the High Court. The doctrine of intergovernmental immunities comes from Chief Justice John Marshall's decision in McCulloch in Maryland. And in that decision, the federal government had created a national bank. There was no power under the Constitution to create banks, but Marshall read the document holistically and said, you know, I can see a power in there. And so it was okay. The legislation was valid. And the second issue was, could the state of Maryland then tax the bank out of existence? And the famous euphemism, the power to tax is the power to destroy, comes out of that decision. In other words, Maryland could not do that. The federal government had an immunity against the encroachment or the attempted destruction of at least the bank in that case. So that's just a thumbnail sketch of what immunities are, and I felt obliged to say that because a couple of people have asked me, when you say immunities, what the hell do you mean? And that's exactly what you mean when we talk about intergovernmental immunities. Now, I come to Richard. Richard was involved various degrees in 3 cases that have impacted on the doctrine as it's developed in Australia. The first was a case that we referred to in the paper as QEC, and that, Richard will talk about this, that involved a massive industrial dispute in the state of Queensland. Richard wasn't actually in the case, but the only reason why it went ahead was that an earlier High Court decision had decided that the mere service of a log of claims to seek a federal award was sufficient to give rise to an industrial dispute within the meaning of Section 135 of the Commonwealth Constitution. The second case, which you can see down here, and there's another small picture that I can hand around in case you can't see it, is a picture of Richard at the bar table. And the reason why the High Court bothered to set up a camera and take a photo is because at that stage it was the largest case that had been run in the High Court. And the reason why it was the largest case is because it involved this issue where a federal award was going to be made that was to bind the state public sectors. And the states argued that this was a curtailment on their government powers to the point of destruction, as they argued it. Now, Richard will talk about his experience in re-AEU. And then the third case was a case that the two of us were in only a couple of years ago. So the first case was 1985, 10 years later re-AEU was 1995, and then 20 years later in 2015 we did a case called UFU and CFA, which has its own interest, but nevertheless Richard was the senior counsel in that case, and happily we won it. Now, just one other thing, as a little anecdote. In the course of re-AEU, there were large questions being asked, and a lot of it had to do with the constitutional history of Australia, and including the importation of doctrine from the US. And it was the first case that had actually struck down federal legislation based on one of the aspects of the doctrine of intergovernmental immunity. But in the course of briefing Richard, they asked some people to do some research, and the apparatchiks in the law firm had contacted him and said, "We found some gold here. We've actually got a thesis from someone that actually deals with all of this, and we feel that this is the basis of the submission." And Richard said, "You beauty, please send it up to me." It ended up being Richard's own master's thesis. So, with that, I hand it over to Mr. Kenzie.
Thank you. It's all contributed to making me feel very old, I have to say. Thank you all for coming along. As Tom has said, the paper that Tom has done, and as you can see that unlike some previous episodes here, we have a situation in which the excellent paper has been prepared by Tom and I'm doing the talking. But it has its origins in, as Tom said, my participation in a number of cases, Australian education in Victoria in 1994, and together with Tom 20 years after that in UFU and country fire authorities, and both cases which involved fundamental questions in relation to the relationship between federal and state governments in our federation. And an aspect of those matters involves something called and you'll have seen if you've had a chance to look at the paper, the Melbourne Corporation principle, which has been evolved as part of the constitutional discussion. I must say, when Tom originally suggested this CPD topic, I had my doubts because he wanted me to talk to you about my involvement in these things, and it sounded a little self-indulgent. But Tom argued correctly that this was a highly significant area of discourse. Indeed, it's fundamental because it underpins legislation in the Federation and underpins any legislation that has the potential to impact on other governments within the Federation. It's a matter of importance, and so we thought that we'd do it this way. The paper, as you'll see, reflects, and the other reason for doing it is because it's not just an important area of constitutional law, but without wanting to sound corny, it's a story. There's an evolving story and a very interesting story that underpins the paper and the development of the doctrines that underpin it. And I wanted to trace something of that story without hopefully boring you too much, but it's important to understand that development and to understand where we are today and how we got here. And the cases that I was in have played some part in relation to the development of that, and it keeps evolving. And as you've seen from the paper, hopefully, the most recent chapter was written 2 days ago when the High Court handed down the decision in Spence in Queensland. And isn't it the way? You go to do a CPD paper to explain how much you know about things, and 2 days before you get to give the paper, the High Court hands down a lengthy constitutional judgment which ended up in a 4-3 decision and 566 footnotes. Such is life. So, look, those of you who've retained some recollection of your studies into Australian constitutional law will recall some of the earlier constitutional developments, particularly in the early years when the High Court got hold of it, and the key phases that underpinned that development pre and post the engineers case. Interestingly enough, many of which involved cases in the employment law area in section 5135. Some of the most important cases, as a matter of history, have involved, engineers included, have involved the area of employment law. Now, the paper on pages 1 to 3 traces the pre-Federation events and the significance of that is that the constitutional debates and the events which gave rise to the Constitution involved the founding fathers developing what they thought was a description of a compact which involved the colonies or the states as equal partners or perhaps preeminent partners. Part of the development of that, which is recorded in Tom's paper, included the development of what became section 106 and 107 of the Constitution. 106 provides that the Constitution of each state of the Commonwealth shall, subject to the Constitution, continue as at the establishment of the Commonwealth until altered in accordance with the Constitution. And 107 provides that every power of the Parliament of a colony which has become or becomes a state shall, unless it is by this Constitution exclusively vested in the Parliament of the Commonwealth or withdrawn from the Parliament of the state, continue as at the establishment of the Commonwealth or as at the admission of the establishment of the state, as the case may be. So the people who wrote those words and developed those words thought that they were doing something which would describe a state of affairs which would factor into a debate about the distribution of power. And Tom's first 3 pages develops and explains that. So pre-1920, at a time when the High Court was populated by members who had themselves been involved in that process, saw the acceptance of the doctrine of implied immunities, as we all know, and that held that within their respective constitutional competencies, both the Commonwealth and the states were independent and enjoyed plenary sovereignty, with the result that one couldn't be directly affected by legislation passed by the other. That concept relied on the notion that the Constitution was a compact, wasn't treated as just any old statute, but it was an agreement, and it was one that relied heavily on the concept of federalism. The paper at pages 3 to 6 traces that period, and there's nothing novel about that. It traces the fact that the pre-engineers period featured a recognition of the reciprocal immunities of instrumentalities based on McCulloch and Maryland, which Tom has discussed, as well as the doctrine of implied prohibitions or state reserved powers referred to, or at least thought to be referred to, in section 107. Now, all of you constitutional scholars over there will also be aware that in 1920 the engineers case came along. When Tom and I were looking at developing this case, we sort of read the engineers case and the fundamental change that was involved in the engineers case. Tom had a copy of Bob Menzies' book. Menzies was the advocate in that case. He was 26 years of age at the time. Think about that, you guys. 26. When he put his preliminary submissions to the High Court, which were submissions within the confines of the pre-1920s learning, he was told by one of the members of the court, I think Justice Stark, that his argument was rubbish. And Menzies responded that, well, if he was given leave by the court to re-argue the cases that had been argued in the first 20 years of the court, he would come back and present. He would be able to come back and present them with an argument that wasn't rubbish. The court adjourned. And came back on. And they came back on the bench. And the Chief Justice said to 26-year-old Menzies, "This matter is adjourned to Sydney, when the parties will be permitted to re-argue the implied immunities cases." And so it was. That led to the sweeping away of 20 years of history and the learnings of the people who'd participated in the Constitution. And as we know, the engineers case led to a conclusion which emphasised that the Constitution was a statute, not an agreement. It led to a departure from American authority. It led to and involved the conclusion that the provisions within the Constitution which actually gave power to the Commonwealth Parliament were to be read in a plenary way and given the full force of the text, with the result that within that text the Commonwealth could bind the states. And it also proceeded on the basis that it was not proper to start the constitutional inquiry by first assuming that the Constitution reserved to states the power to regulate their own internal affairs, and to that extent the notions of equality between the states and the Commonwealth were fundamentally abraded. It basically meant that the approach from here on in was to work out what the Constitution provided in the way of Commonwealth power, work that out first, and the states got the rest, which was a fundamentally different approach from the historical approach, and indeed from the approach that had been thought to be appropriate by the founders. The engineers case has been criticised in a number of academic and other quarters for it's nearly 100 years ago now. It'll be 100 years next year. Now, again, as those of you who are still paying attention in constitutional law classes will know, the engineers case didn't mean that there weren't that implications were completely removed from the Constitution, and after the engineers case there was an appreciation that there were reservations to the notion that the Commonwealth could do anything within the enumerated powers. So it was thought that there would be qualifications in relation to laws which discriminated against states, laws which infringed on the state government prerogative, priority in relation to the collection of debts, limits on the power of enforcement, possibly the taxing power, based on the notion that the power to tax is the power to destroy, and suggestions that there might be limitations flowing from section 106 to 107 of the Constitution. Now, a lot of those were eliminated from the scene over time. A number of things happened after the engineers case. First of all, the power of the Commonwealth to pass a general taxation law applicable to employees of the states, not states themselves, was upheld in the payroll tax case much later in the 1970s. The High Court held that the prerogatives of the Crown in right of the state could be adversely affected by federal legislation. But most importantly, those considerations went one way. After the engineers case, there were a raft load of events which had the effect of further changing the relationship between the states and the Commonwealth government. They were both legal. They were both developments that took place in the courtroom and developments that took place more generally. So in 1926, and the paper traces these. I'm going to pass more quickly over them, but they're part of the story. So in 1926, in Victoria and the Commonwealth, the High Court, interpreting the Constitution literally and legally as the engineer's case instructed, came to section 96, which is the state grants power, the power of the Commonwealth to grant financial aid to the states. And so it relevantly provided that the Parliament can grant financial assistance to any state on such terms and conditions as the Parliament thinks fit. And the High Court determined, crucially, that meant that the Commonwealth could condition any grant of financial aid on any terms that it wanted, regardless of whether those terms related to heads of constitutional power. So it meant that the Commonwealth could provide money to the states and condition the grant of that money on the basis that the states would do something that transcended Commonwealth power. That fundamentally changed the nature of things, obviously, and the balance. In 1942, the High Court upheld the uniform taxation legislation. What happened there was a series of separate acts passed which weren't related to each other on their face. The net effect of the legislation was that the Commonwealth would provide financial aid to the states, provided the states would not get such reimbursement if they levied their own income tax. And that was it was described as not just an inducement but almost a bribe or compulsion. But the High Court upheld that, and that obviously gave rise to the system of uniform taxation that we've seen since the 1940s. But again, the High Court was not persuaded by the argument that the Commonwealth was leaning on the states and effectively depriving them of choice as to whether they levied tax or not. So those sorts of developments, post-engineers, changed the nature of the balance, and the position of the Commonwealth had waxed and the position of the states had waned by the time of the Melbourne Corporation case in 1947. So the Melbourne Corporation case came around, and again Tom's paper has traced this. That dealt with federal legislation that was designed to force the states to bank with the Commonwealth Bank. The legislation, the section in question provided that except with the consent in writing of the Treasurer, a bank shall not conduct any banking business for a state or for any authority of a state, including a local government authority. And the High Court, that was challenged in the High Court, and it was declared to be invalid. And if you look at Tom's, it was the first occasion after the engineers case that federal legislation had been struck down on the basis of implications flowing from the Constitution. So it was the first tangible evidence that notwithstanding the engineers case, there were some implications there that could be called upon to actually strike down federal legislation as not being supported by power. The bases upon which that was done are elusive for reasons, again, that Tom has traced well in the excellent paper. And if you look at pages 10 and 11, and we won't be pausing. It's not that sort of lecture. But if you look at pages 10 through to 12 of the paper, you'll see that of the majority judges, Justice Rich and Justice Stark, they struck the legislation down on the basis that it was that it struck at something fundamental to the state. They reasoned that it was fundamental to a state to be able to conduct its banking arrangements on a basis that it could get finance, and a legislation that put in the hands of a federal entity, the Commonwealth Bank, the chance to stop the checks and everything was a fundamental attack. So they approached it on the basis that it was a general piece of legislation that had that particular effect. And they said an implication that flowed from the Constitution was that you couldn't damage the capacity of a state to do what a state had to do. On the other hand, and this is the source of much that followed, Justice Dixon, who was generally regarded as knowing what he was talking about in this regard, he focused on the notion that the legislation was about what states could do. So it was legislation that was aimed at a state. And he thought that the law was invalid as one which discriminates against a state, or a law which places a particular disability or burden upon an operation or activity of a state or upon execution of a state's constitutional powers. So there's, in Dixon's judgment was the clear hint that he was looking at the directed nature of the legislation, and that it was actually aimed in some way, for example, at controlling a state. And and so what you had after that time was clearly the notion that there were implications there, and a question as to how those implications were to be formulated or understood. In the years that followed, there were a number of cases that without tracing the detailed history, that actually further refined what the limitations on Commonwealth power were in a way that gave some clarity to those matters. There are a number of those cases, but the significant amongst them was, for those who are old enough to remember, the Tasmanian dams case. If you can remember that back at the early 1980s, the federal parliament passed a series of acts utilising the corporation's power and the external affairs power. And what they were seeking to do was to prevent the damming of Lake Pedder, and the legislation prevented the Tasmanian government from going ahead with Lake Pedder and impacting on 11% of the area of the state of Tasmania. And that was challenged on the basis, a number of bases, but one of the bases upon which it was challenged was that it interfered with the capacity of the Tasmanian government to make decisions as to what it was going to do with that 11% of its state. The significant thing about that aspect of the case was that the High Court, or the majority of the court, said that the protection that was provided by the limitation, I'm quoting from Mason and Brennan, was with the capacity of the state to function as a government rather than interference with or impairment of any function with it which a state government might happen to undertake. In other words, this gets back to the question of whether you decide that matters are innately governmental, and are they innately governmental because the government decides to do them? How do you deal with that? The the High Court was saying, well, if whatever the limitations are, if they don't provide a basis for invalidity because they attack the nature of activities rather than the nature of the decision to exercise the power to exercise constitutional powers. So that was a fundamental distinction that underpins and continues to underpin the approach to the Constitution. Now, by the 1980s, and I am getting to the stage of involvement, but by the 1980s, various members of the court had come to describe the principle as involving two discrete parts because of the history that I've tried to describe, probably not clearly enough. One of the cases in which that happened, and probably the most significant case in which that happened, was the case that Tom has mentioned again. That was the Queensland Electricity Commission against the Commonwealth. And that case, as Tom has said, arose in the context of a very significant industrial dispute, the biggest industrial dispute of the 1980s probably. While Queensland was shut down by the CEQB dispute, the High Court had found that there was a valid log of claims served by a union who wanted to get industrial results. The fight was a fundamental one between Bielke Joe and the federal government. The government, led by the now late Bob Hawke, decided to legislatively intervene. And the way they legislatively intervened was to pass legislation that impacted on a proceeding. It was the proceeding that I was in, and that proceeding was a proceeding whereby the Queensland government was seeking to get an order that the industry continue to be regulated by the State of Queensland rather than go federal. And the federal Parliament passed a law that said, in such proceedings, the power to rely on public interest considerations is gone. So the federal government intervened, but it intervened in relation to a proceeding that was challenged in the High Court in the QEC case, and the challenge was successful. And Justice Mason crystallised the principle as was then understood, and he said that the principle is now well established and consists of two elements. First of all, the prohibition against discrimination, which involves the placing on the states of special burdens and disabilities, and secondly, the prohibition against laws of general application, which operate to destroy or curtail the continued existence of the states or their capacity to function as governments. So, bob each way. And the first was a reference to what Dixon had been referring to in the Melbourne Corporation case. And the second was a reference to what Stark and Richard had been talking about in that case. The legislation was struck down in that case. Now, that legislation was not legislation which was going to empty out the state of Queensland. It was legislation that impacted on a part of a proceeding that the state of Queensland happened to be running at the time. It was no big deal as far as an attack on constitutional power, but the High Court decided that it was invalid. So it was the second example of implication of the application of implications from the Constitution, and the first, subject to accepting that the Melbourne Corporation was about discrimination, to actually strike down a legislation that wasn't legislation of general application, but was legislation that was perceived to be aimed at the states. And that, folks, is the general situation that was prevailing at the time of the argument in Australian Education Union in Victoria in 1994, which was the case in which I was briefed to defend the application of federal industrial laws generally to the state of Victoria. What had happened there was that the federal industrial laws had been applying happily since 1904, and since the engineers case, they'd been applying to everyone, including state employees, or thought to be applying to state employees. The law in its form permitted the Industrial Relations Commission to arbitrate industrial disputes, to make an award having the force of law, regulating the industrial conditions of employees embraced by an industrial dispute. Those conditions included wages, other conditions of employment, and matters which included the manner and mode of termination of employees. And by the time of the argument in the case, the Commission had actually proceeded to make some interim awards regulating the dismissal of employees within the Victorian Police Service, and that was the time. The time was the introduction of the Kennett government, and he decided to take the Commonwealth on, as some of you may remember, and actually reset the laws in relation to how far the Victorian industrial relations system could be affected by Commonwealth law. So that case was seen as having fundamental importance. It involved a frontal attack on the federal jurisdiction in the employment area. It was supported in one way or another by all of the states, who all had their own view about what the rules should be. And that's why 22 council gathered in the room, and that's why the High Court took that picture, because everyone rolled up and had their own view of the world, what the qualifications should be, whether there should be any, and how it was going to actually come out. It was argued by the Victorian government that the federal legislation infringed the Melbourne Corporation principle because it interfered with or curtailed the state's governmental functions and its capacity to function as a government. It was said that the limitation wasn't confined to essential government functions, but protected the state's capacity to function as a government. In other words, whatever the government decided to do as a government was protected. It was argued that the legislation affected governments more than people generally because they were governments. The prosecutor's submissions, the government submissions, were reminiscent of the acceptance of a distinction between trading and governmental functions, because the prosecutor said it didn't matter. On the other hand, we argued that the federal industrial laws were not invalid simply because they impacted on state activity. For example, they weren't invalid because they meant that if an award was made, wages would have to be paid and wages would have to be increased, and that would impact on the Victorian Treasury, and they'd have less money to do whatever they wanted to do. That didn't matter, we said, and we also argued that the distinction between essential functions of government and other functions performed by governments were illusory, on the basis that anything done by a government could be said to be governmental, and it wasn't a helpful distinction. And both of those submissions were accepted by the High Court, which determined that there was no constitutional vice in the imposition of general industrial laws impacting on the activities of public servants of a state. So the major premise of the Act failed. So we won the fundamental point, which was the frontal attack. But the states had success in relation to the minor premise of the attack, which related to the validity of the interim awards regulating termination of employment. So there had been some interim awards made, and they regulated the manner and mode of employment and termination, and they provided that the termination could only take effect in accordance with a fairness regime and the like. And the High Court struck those down. It determined that although we won the major premise, that the court determined that aspects of the state's functions which are critical to its capacity to function as a government included the government's right to determine the number and identity of the persons whom it wished to employ, the term of appointment of those persons, and as well the number and identity of the persons whom it wished to dismiss with or without notice. So in other words, for a government to function, it had to at least be able to make decisions as to who was going to do what they wanted done, whatever it was. They also determined that it was fundamental to a state's capacity to function that in relation to people at the higher levels of government, all of the terms and conditions of employment be able to be determined by the state. And so on that basis the interim awards were struck down, but the regime of federal law in relation to the state's survived. But that successful attack on the interim awards, represented the first time since the Melbourne Corporation case that action based on non-discriminatory federal legislation was struck down on the basis of the Melbourne Corporation principle. Now, that was the state of affairs which existed in the mid-1990s, still against a background in which the principles as described to the court were the principles as had been enunciated in the Queensland electricity case 10 years before. What followed, traced again by Tom in the paper, which follows the story, were some cases from 2003, and there were three significant cases. The first of which was a case called Austin and the Commonwealth in 2003. And in that case, the court declared invalid a Commonwealth Act regulating arrangements made by states for the remuneration of their judges, and it found that the legislation had the capacity to affect the recruitment and retention of judges to perform essential constitutional functions of the state. There's nothing significantly surprising about the conclusion in Austin, but what was significant about the case, and I'm now talking about three cases that are decided by the High Court after the AEU case I was in and before the next case that Tom and I were in 10 years later. This is one of them. What was significant about what they did in Austin was three members of the court said, in relation to the description of a limitation, there is in our view but one limitation. Though the apparent expression of it varies with the form of the legislation in question, the question presented by the doctrine in any given case requires assessment of the impact of particular laws by such criteria as special burden and curtailment of capacity of the states to function as government. They are to be applied by consideration not only of the form but the substance and actual operation of the federal law. Further, the inquiry inevitably turns on matters of evaluation and degree and of constitutional facts not readily established by objective methods in curial proceedings. So what the majority was saying is, look, the issue can be narrowed down to asking whether the burden on the states comes about by a significantly sufficient impairment of the exercise by the state of its freedom to select the manner and method of discharge of its constitutional functions. And they asked the question, well, looking at the substance and operation, not necessarily the text alone, but the substance and operation of the federal laws, has there been in a significant manner a curtailment or interference with the exercise of state constitutional power? In the later case of Clark, 6 years later, the majority reiterated doubts earlier expressed about a focus on discrimination, because you'll see that in Austin, the focus was off discrimination. The focus was on a more general question. So the focus was off what Justice Dixon had been talking about in the Melbourne Corporation case. Four members of the court in Clark in 2009 said, too intense a concern with the identification of discrimination as necessary to attract the Melbourne Corporation doctrine involves the search for the appropriate comparator, which can be a difficult inquiry and is apt to confuse rather than focus on the answering of the essential question of interference with or impairment of state functions. And they said it may be that the reference to discrimination by Justice Dixon used the term in the somewhat different sense of a law which is aimed at or places a special burden on the case. That approach was subsequently approved by four members of the court in a subsequent case called Fortescue, and Tom and I have our views about Fortescue, but certainly the text of those cases were formally approved by four members of the court in Fortescue, which has been again identified in Tom's paper. So that was the situation that prevailed at the time that Tom and I were briefed in the next case, which was the UFU and the CFA in 2014. In that case, we were briefed to defend the validity of an enterprise agreement which had been certified under the federal industrial fair work legislation. That legislation provided a regime for the making and certification of industrial enterprise agreements on matters permitted by the legislation. Those matters clearly extended to provisions embracing the number and identity of employees of an employer of a state instrumentality and a government. In the instant case, the employer was the Country Fire Authority, an instrumentality of the Victorian Government, and accordingly capable of coverage under the Melbourne Corporation principle. The agreement which had been certified, which we were asked to defend, was an agreement which stipulated the number of firefighters required to be engaged at stations throughout Victoria, and it also contained provisions determining the means whereby their services could be dispensed with. So it was conceded that the subject matter of those agreements were exactly within, were well and truly caught within the description of the High Court in the earlier 1994 case, number and identity of employees. We argue that agreement was attacked as one embraced by the decision of the court in AEU, unsurprisingly, and you will appreciate that the substance of that challenge was based on the notion that the agreement, when certified, had all of the same characteristics as the award in the AEU case. In other words, if in the AEU case there's an arbitrated award, the award's made, it covers the instrumentalities. If it's breached, someone can sue on the award, someone can seek penalties for breach of the award, and if it's a government, they can be called to account. And called to account in relation to the number and identity of employees, held not to be possible in AEU. So it was said by those who attacked the agreement, well, it has the same ultimate character in terms of confining the government of the state of Victoria. We relied on the general nature of the legislation. We said this is just general industrial legislation which permits the making of agreements with, as to define content, and we sought to distinguish it from an award which resulted from an arbitrated outcome, which was the subject of the decision in the AEU. At first instance, we failed, with the primary judge applying AEU and determining that AEU, effectively providing a sub-rule of the Melbourne Corporation principle, precluded the certification of an enterprise agreement which identified the number or identity of employees to be employed by the State of Victoria or its agency. And the judge regarded the existence of agreement as irrelevant and focused on the fact that the state was effectively curtailed by the agreement, even though it was an agreement. On appeal, of course, we relied again on the fact that the agreement was voluntarily made, although it was made in the context of the Federal Act, which permitted federal industrial action and action by employees to seek to bring an agreement about, emphasising, as we did, that attention was required to be paid by the more recent authorities on the substance of the interference and the questions of practicality and substance and degree. The full court, those submissions were successful, and the appeal was upheld. The full court traced the development of the High Court authority post AEU, Austin and Clark and those authorities which had intervened since 1994, and said the relevant provisions of the Act did not single out any state or its agencies. The relevant question is whether those provisions imposed some special disability or burden on the exercise of the powers and fulfilment of the functions of the State of Victoria or the CFA, which curtailed the state's capacity to function as a government in circumstances where the CFA voluntarily agreed to make the enterprise agreement. We don't consider the provisions offended the implied limitation. In particular, we don't consider that the statutory regime for the making an approval of an enterprise agreement had the effect on the state government functions of the Commonwealth, imposing on the State of Victoria a significant impairment, interference, curtailment, control or restriction so as to attract the limitation. In our view, the voluntary nature of the agreement is inconsistent with the concepts which is at the heart of the doctrine. They went on to say, look, if the evidence went on to disclose perhaps that the state had been held to ransom, for example, if there had been a 6-month strike and the state was on fire and the firefighters wouldn't work until there was an agreement, they said we might have to think again. Is that right or wrong? We can talk about that. They did say that, but we succeeded because the court asked the question of whether the legislation which permitted that outcome constituted as substantial interference. And they said this legislation that permits people to voluntarily decide doesn't have that characteristic because it needs to be a substantial impairment, applying the more recent authorities, which look at matters of substantiality and degree. And I mean, it's a kind of a microcosm of the argument that looks at the susceptibility of a state government to general laws. So, for example, the position of the state government under the trade practices legislation, or any federal legislation that regulates, for example, commercial matters or a contractual matter. The state, the general proposition would be that the constitutional principle is not attracted, the implication is not attracted, because the state government authority has got to abide by the law of the land in relation to contractual or commercial law. It's not that. That's a law which interferes with its functions, what it does on a daily basis, but doesn't interfere with its constitution. And what the court was saying is, look, this legislation really allowed the making of a voluntary contract, which caught the state arm, and although it involved ingredients which wouldn't have been permitted had it been involuntary or arbitrated, it didn't matter. It was valid. So, again, those matters reflect the development of the principle, and you can see that as it's developed, it's certainly come to involve matters of substance and evaluation, but it's developed in such a way as to potentially obscure the question of where, for example, discriminatory law fits into the scheme of things. So in the 1980s, the High Court had accepted that there was a double-barrelled set of principles, and but by the time these cases were argued, the High Court had had another look at it and had said there's really just one principle, and giving rise to the question, the obvious question, as yet unresolved as we speak. Well, okay, if a law has it's one thing to say that a law might have a substantial impact on the constitutional operations of a state government, but what is the fate of, under the new view of the world, of a federal law that is discriminatory, simply discriminatory? Because the principles accepted back in the 1980s, the double barrel arm, said if something's aimed at controlling the state, it's discriminatory, and the principles were capable of supporting the conclusion that it was bad because it was discriminatory. And it was also bad if it was a law of general operation that actually had a particular effect. But Dixon's judgment is capable of supporting, and was capable of supporting, the view that if the Commonwealth passed a discriminatory law against states, it was bad without more. In other words, bad without engaging in the discussion as to how significant the impairment was. Those matters, questions are thrown up, but not satisfactorily resolved by the authorities. Indeed, in Austin and Clark, Justice McHugh, who didn't share the view that the rules had changed, he questioned that and said, effectively, what are you doing? There was a perfectly good set of principles here, and this actually merges concepts in a way that is not necessarily supported by the authorities. Tom's paper makes the valid point that the developments that have taken place this century have actually had the potential effect of blurring the first of the principles discussed by Mason, the discrimination principle, making it perhaps a subset of something, but enhancing or broadening the reach of the second set by saying, well, we'll have a look at it if it's in substance interferes, well, that's enough, whatever the text may appear. But in any event, something's going on, and the questions that are raised are the questions which we've attempted to capture and Tom's attempted to capture in his paper as to just what's happened as a result of the attempt to condense two propositions into one. There's a whole other area of discourse which I'll attempt to deal with more briefly, but the recently decided case of Spence dealt with the application of the Melbourne Corporation principle to federal laws, Commonwealth laws, but it also had there were two pieces of legislation challenged, and the challenge was a challenge not simply to Commonwealth laws in that case, but to corresponding state laws, and so raising the question as to what are the set of rules in relation to state laws as far as constitutional implications are concerned. This is a totally it's a similar but different area of discourse. And if I could just say something to you about it before coming to Spence, and keep this brief. In the engineers case, the court said the principle that was applied to Commonwealth laws was also applied to the states, leaving their respective acts full operation within their respective areas, but in the case of conflict, giving to a valid Commonwealth legislation the supremacy expressly declared by the Constitution. What they meant was that, look, whatever the area of operation of states' law is, there's an area of operation, and the states have got to operate, and so there's room for implications the other way, potentially room for implications the other way, namely that the Constitution can contain implications that protect the states as well as the Commonwealth, but against a background in which, as between the states and the Commonwealth, there's a mechanism within the Constitution that ensures that the Commonwealth's position is always stronger, and that is Section 109 of the Constitution. So that if the Commonwealth actually acts in an area of its constitutional capacity and it's inconsistent with the state, well, it prevails as a result of Section 109. And so the question that has existed for a long time, since the engineers, is, well, what is, if any, the extent of state protection by the on the other side of the coin, and secondly, is that affected by Section 109, by the existence of Section 109? If you've got Section 109, do you need any further implication? In other words, so from the earliest days after the engineers case, the court looked at the change in the rules that the engineers case had affected on state law as well, and I sound like an equity lawyer, but I was going to say as early as recently as 1925. do that. The court held that a member of the armed forces was subject to state law relating to driver's licences while driving a motor vehicle when on duty. And in West's case in 1937, the court held that the superannuation pension of a person who was a public servant was subject to state taxation. So there's been an acceptance that the Commonwealth is not immune from state laws, but the question has always been, well, what is the extent and nature of that immunity? There are some very difficult authorities in relation to this, and I'm thinking of cases like Bogle and a case called the Commonwealth and Sigomatic, where the High Court followed Chief Justice Dixon in holding that the Commonwealth was not bound by the Companies Act of New South Wales, which prescribed an order of priority in discharging debts in a manner not consistent with the prerogative right to priority claimed by the Commonwealth. So there's an area of immunity that's Sigmatic's an example of that, but there's an area of liability. For example, Perry and McFarlane, if you've got your military drivers out driving around the place, they've got to have a state driving licence. And so the question, and it's funny how many of the significant, you think this is a pretty significant question and you think someone would have got around to resolving it pretty quickly. In fact, for years after Sigmatic, which was decided in the early 1960s, this remained entirely unresolved. And the first time the High Court came to grips with it after Sigmatic was in 1997, where in a case called the Defence Housing Authority, where there was an application to a state tribunal to allow owners of a property to inspect premises and obtain a key was made against a Commonwealth authority which had entered into leases for defence personnel. Reliance was placed on Sigmatic, and the federal authority said we're not liable, you can't make an order against us. But the High Court said that the Commonwealth authorities were liable, and reliance was placed on earlier reasoning, including Sigmatic, and a distinction was recognised between laws which purported to modify and impair a state executive power affecting a state capacity, and laws which assume the existence of such capacities and merely seek to regulate activities carried on in common with other citizens, getting a driving licence and things like that, as opposed to a law which is designed to attack a Commonwealth capacity or a prerogative. So that some line is sought to be erected and was sought to be erected like that, always subject to Section 109. If the Commonwealth can affect the debate by passing a valid law, well, it can end the debate by passing a valid law. And again, sounds easy, sounds sensible, but it masks a number of practical questions which it's beyond time here to go anywhere near. But Justice McHugh, for example, in that case, he looked at that and said, not nearly good enough. He says, can a general state law validly regulate the Commonwealth transport system? Can it insist upon compulsory insurance for and periodic maintenance and inspection of Commonwealth vehicles? Can it require that the Commonwealth to use only drivers licensed by state law? Some of those, you might think the answer to some of those questions is yes, but he recognised that there are serious lines to be drawn and in that regard. The jury's out in relation to in relation to that question. Now, that leads me finally, and I'll stop very quickly, I promise you, but I need to say something about Spence's case, because the ink isn't dry and it's a very significant case, handed down just to thwart attempts to end this CPD on a questioning note and the like. Spence was a case concerned with electoral law affecting Queensland. There was the Queensland Electoral Act was amended to provide that property developers could not, that political donations could not be received from property developers by political parties, and parties were identified. The parties were political parties like the Liberal Party, like Pauline Hanson's One Nation. They were all nominated, and they were people who could participate in a state or a federal election. They were political parties. So the Act had potential to affect donations to people who were participating in federal elections as well as state. That was challenged as invalid under the Melbourne Corporation, under what was described as the reverse Melbourne Corporation principle. So the plaintiff came along and said, look, what's good sauce for the goose is sauce for the gander. That's a state law, but if you applied the same sort of principles as you applied in the Melbourne Corporation and applied them to that, it would fail. The next thing that happened was that the Federal Parliament passed an amendment to the Federal Electoral Act, which imposed a new and different but less rigorous set of rules about political donations from what were called foreign donors, or words to that effect. And it was said that those provisions were inconsistent with the Queensland Act, so there was an additional barrier. There was an additional problem with the Queensland Act. It was both bad in its own right and bad because it was inconsistent with valid federal legislation. The response of the Queensland Government was obviously to defend its own Act, but also to attack the Commonwealth Act as beyond power. The reason for the attack on the Commonwealth Act was because it was said that the Commonwealth Act was also careless in terms of its application. It, like the State Act, was capable of catching people who were participating in a state election, and because it wasn't on its face confined, and it was said that that took it beyond Commonwealth power because state electoral law was not within the legislative power of the federal Parliament. And indeed it was said that there was nothing in the Constitution which enshrined electoral law as an exclusive power, although it was accepted that the Commonwealth would have had power to legislate in relation to Commonwealth elections as it's done in the Commonwealth Electoral Act. So there it was, and you'll there find the seeds of a whole series of debates. What happened was that the court divided 4-3 in relation to the validity of the Federal Act. So 4 members of the court said that the Commonwealth didn't have power to pass a general act which affected state activity simply because of the possibility that some of that money might find its way into a federal election. The might wasn't good enough to justify the result. So 4 members of the court didn't have to decide whether the Commonwealth Act, which was also challenged on Melbourne Corporation grounds, offended under Melbourne Corporation. Three members of the court decided that the federal legislation was valid and accordingly had to address the question of whether it failed for Melbourne Corporation grounds, and those 3 members of the court decided, and Thomas chased the reasoning in his paper, that the Federal Act, if it was valid, didn't fail for Melbourne Corporation grounds, even though it did intrude and cut away some of the options that the Queensland government might have in terms of how financing for elections was to be controlled. As a matter of substance, it didn't do anything substantial. It left the Queensland government a whole range of options in terms of electoral law, and so it wasn't a fundamental attack. So that you'll find that there's 3 discussions about that in the court judgment. Perhaps more significantly, it was what happened in relation to the challenge to the State Act, which had to be addressed, and in relation to the State Act, addressed by all members of the court, the challenge to the State Act, you'll remember, was a challenge based on the notion that there was a reverse Melbourne Corporation principle at play. It was argued by the Queensland government that there was no reverse Melbourne Corporation principle, and it was argued that there was no need for a Melbourne Corporation principle because of 109. The High Court all dealt with that, and all but Justice Gordon said there was a reverse Melbourne Corporation principle. So this case 2 days ago is the first, coincidentally to this CPD paper, is the first time the High Court has expressly recognised as a court, a majority of the court, that there is a reverse Melbourne Corporation principle entitling you to ask the same questions about a State Act as been asked historically about a Federal Act. And what the court said a number of things which I won't trouble to detail, but the majority said, well, we're doing this, but we don't think we're reopening the door to a revision to some kind of reciprocity and reciprocal implied immunities that we used to have before the 1920s. Now they said that, but you can bet your life that the next thing that the academics are going to be doing is questioning the veracity of that, because as we speak, you've now got the Melbourne Corporation principle operating on both sides of the ledger. And the second thing they said was that they didn't regard the the existence of Section 109 as a sufficient reason for denying the existence of that principle. And what they basically said, why should the Commonwealth Government have to go to the trouble of passing legislation to protect itself? The same rules should apply. So that's where we stand as of 2 days ago. The members of the court that found the existence of that principle, however, said that it wasn't offended by the facts of that case. In other words, they said that a reasonable degree of control of financing elections was not something that struck at constitutional power in the way necessary for the principle. So there was in the end, no principle was applied in that case. But the significance of the case is, as I hope I've illustrated, that it opens a new door, and in relation to state legislation, and questions about whether we're now back in a world of reciprocity. So that coincided nicely with our paper. I'm sorry to have taken this long. What I think Tom and I have been anxious to do is to really demonstrate that this is it's an evolving story. This is a truly evolving story. It's gone round the corner and back again, and on one view it's just taken another slight turn and continues to do so. And it's surprising to see that having happened with the frequency and determination that it seems to have in relation to something that is so fundamental. We've waxed and waned in terms of our adherence to and following of American lines of thinking. The gap has gone out and back again in a manner that Tom's paper well illustrates, and we're just taking another turn. Although the High Court, the majority is at pains to say they don't think it's that much of a turn. Is there something else you think, Tom? I think that's basically the story, and it's taken a little bit of time to tell, but something's happened at every stage, and we didn't want to leave anything bigger.